Good afternoon, everybody. My name is Debbie Faulkner with Burke Faulkner Law, and you are watching a seminar today on asset protection and what it means. I have had a lot of clients in the past few days and the past couple of weeks contact me nervous about what's going on in today's global economy. As we all know, the money that we previously had in the stock market may not look so good these days. We're kind of in an unprecedented time where a lot of people are getting concerned not only with the money that they previously may have had seemingly secure in the stock market growing for their benefit, but also, personally speaking, a lot of people are worried with being furloughed from work and not being able to make ends meet per se. It's definitely a present concern nowadays. And I just want to let everybody know up front, I want to ask you to please subscribe to this channel. Please subscribe to our channel, and that will give you updates for future seminars that we're going to do. Today's seminar, we're talking about strategies in asset protection planning, and we are going to do for individuals today. And next week, I'm going to do a different seminar on asset protection planning strategies for business owners. So there's a lot of multifaceted strategies that can take place when you have a closely held company like an LLC or an S corporation or a partnership that are really not applicable to, everyday individuals that you may receive your primary income from a business and not from your personal company. So I also want to invite everybody who is out there, if you have questions, feel free to ask them in real time. I have it up on the screen here. I'll be able to answer you verbally with any questions that you may have. Whatever question you have, other people probably have the same question. So don't be shy. Send me questions as we move along. So asset protection is really two different conversations. The first conversation is what are the assets that I have and are they protected right now? And the second part of the question is what is my liability exposure? And then how do I mitigate the risks of what I'm exposed to? So I want to begin the conversation kind of talking about the assets that most individuals have. The first thing is most of the people watching here today probably own a home. I want to let you know that, one of the main concerns people have is if I ever get into trouble and get behind on my bills and I get sued, is my home protected? In Florida, in general, Florida is one of the best states in the country for asset protection planning. Florida has one of the most liberal homestead statutes in America. Now, homestead in Florida is a very specific, legally defined property. It is the property that you declare as your primary residence, and it has constitutional protections under Article 4 of the Constitution. And there are also two statutory elements of homestead planning that prevent creditors from essentially taking your home from you if you ever to get in a lawsuit. There are a couple of creditors that are what I call super creditors that are able to attack your house if you ever were to fall behind. As many of you already know, your mortgage company is definitely one of them. But what a lot of people don't know is that your homeowners association also has the power to foreclose on your home. So in these rough times, we all are probably watching COVID-19 news routinely every night for most of us, maybe all day if you're at home with kids. But there are a lot of mortgage companies right now that are able to offer you forbearance programs and things like that so you don't fall behind in your mortgage. But just know that there's the IRS, your mortgage company, and a homeowners association are some of the only creditors that can ever touch your home in Florida. So the second thing I'd like to talk about a little bit is vehicles. So a lot of times I have couples come into my law firm for their estate planning, and we talk about different assets that people have. And families typically are two-car households these days. Well, cars are one of your highest liability assets that you have. Most people, aside from having an economic meltdown in a situation like we are in today, your highest exposure to liability is if you own a company, depending on what the company does, and if you have a vehicle, a wave runner type of thing, a boat, something like that. Those are all high risk vehicles, high risk assets that you may have. In the state of Florida, if you were to get in a car accident, you, the driver, the person who's driving the vehicle at the time of the accident, is the only party that is responsible for what happens in the accident. However, there's a caveat under Florida law, and this is why I'd like to bring up the fact that in Florida, at least, titling is everything. So in Florida, if you, for example, have a child that you have driving one of your vehicles and your child gets in an accident, if your child is at fault, they're the driver that's responsible for paying the injured party in an accident. But the law allows for personal injury attorneys to also include the owner of any vehicle that is being driven and involved in an accident, so long as they can at least allege that the owner was negligent when they allowed the person to drive. So guys, as you might imagine, based on the number of personal injury billboards out there, if you own a car in your name and you let your son or daughter drive that vehicle, you bet your bottom dollar you're going to be roped into that lawsuit, and your personal assets could potentially be exposed in that situation to a judgment creditor, in this case, the injured person in the motor vehicle accident. I'd like to tell you a little horror story that happened with a couple that came in for a consultation. A husband and wife just inherited approximately $7 million from the wife's parents. A few weeks after the inheritance went through and the wife received the $7 million, the husband and wife went out on a date to a restaurant to celebrate. The husband and wife don't exactly know what happened next. They had a few drinks. According to them, they planned on Ubering back home, but that never actually happened. What happened is that the husband ended up walking away from the table with the wife. The wife thought that the husband went to the bathroom and was coming back, but he said that he doesn't remember anything that happened and he likely got drugged. He ended up leaving the restaurant in their vehicle and hitting a vehicle with 4 individuals in that vehicle, causing catastrophic injuries to multiple parties, although thankfully no loss of life. Because the wife owned that vehicle and the husband was under the influence of various substances at the time that he got in the crash, that allowed the personal injury law firm to sue not only the husband, who is the driver, who is the at-fault party in the accident, but to also rope in the wife to that lawsuit, because the wife, in the eyes of the law, negligently allowed her husband to drive that vehicle. In other words, he was drinking, he drove, she let him drive, she's at fault too. So this was a potentially catastrophic financial situation for them, because the inheritance that she just had, if she's party to the lawsuit, is now exposed as well to any potential creditor, which in this case would be the 4 injured parties in that accident. So one strategy you can do right now is, if you and your spouse or a son or daughter have vehicles that are titled in multiple names, I would advise for each of you to put your primary vehicle in only one person's name. This doesn't affect your insurance coverage, because insurance is bundled by household, not by the title that's on your vehicle. I'd like to talk a little bit more about IRAs, 401ks, and pension plans. So these are also what's considered under Florida law to be creditor exempt assets. So a lot of times clients come in and they're concerned, if I ever have a financial meltdown, in this climate, let's face it, it's probably, I'm not able to pay my mortgage, I'm getting behind on my rent obligations, I'm not sure I can make my car payment. There's 2 different types of creditors. There's secured creditors, that would be a mortgage company that can foreclose on your house, or if you own a vehicle that's financed, your secured lender is able to take back the vehicle if you're unable to pay for it. And then there's unsecured creditors, like credit card companies that you may owe money to. They have 2 different types of remedies that they're able to go after. So a secured creditor is able to take back the collateral that you pledged to get the loan. So in the case of your mortgage, your house is the collateral, so your bank is able to come and repossess essentially your house. And in a situation where you have a car and a car loan, the lending company can repossess that car if you get behind on your car payments. But credit card companies are an unsecured creditor. The only way that they are able to come after your assets is if they sue you in a court of law and they're able to win a judgment. So if that ever happens to you, where somebody is suing you in court and a judgment gets filed against you, the question is, what assets do you have that you could possibly lose to that creditor? So we've already gone over your homestead. In most cases, unless you're brand new to the state of Florida, your creditors or judgment creditors cannot touch your home. That's your homestead property only. Rental properties and properties that you own that are not in your individual name are potentially exposed to a creditor. Your vehicles are a secured creditor, so they are potentially exposed, but one vehicle under Florida law up to $4,000 in value is exempt from being taken by a creditor. Your IRAs, 401ks, and pension plans are where a lot of Americans store a lot of their assets and their money. These are considered creditor protected, creditor exempt assets in Florida. What that means is that if you are sued and you lose, that a creditor cannot come after your 401ks, pension plans, and IRA accounts. They are absolutely protected. So sometimes this brings up the question, if you are of the age where you're able to take some living expenses and such out of different accounts, if you are concerned with potentially having a lawsuit against you in the future, if you have unprotected accounts and protected accounts like 401ks, you would want to spend down your unprotected accounts. Unprotected accounts include checking accounts, savings accounts, and individual money and brokerage accounts. But here's another caveat that's very important. As I mentioned earlier, titling is everything. So let's go back to the scenario where I get in a car accident. Or perhaps let's take the more probably pertinent example at the moment, and I have a credit card company. I can't pay them. I've just been furloughed from my company. I have no money to pay my credit cards, and I am probably going to have an issue taking care of my payments. Any money that I have in my personal name at that point is potentially in my savings accounts and checking accounts could potentially be subject to any lawsuit that the credit card company files against me. However, if I'm married and I have that money in an account called tenant by the entirety with my husband or wife, then that money cannot be taken by creditors. This concept of tenants by the entirety is an interesting legal concept. It's a legal fiction that basically says that if you, as husband and wife, it's only available to married couples, husband and wife and wife, husband and husband, open an account together at the same time as a married couple. You cannot convert an account from when you were dating and still living together and then you got married. Doesn't count. Has to be an account that's opened by a married couple together at the same time where you both have equal ownership rights in the account. It has a protection called tenant by the entirety. What this means is that if my personal credit card company, I'm the only person that owes that credit card company money. So if I was sued by my credit card company, the account that I own with my spouse is protected 100% from the creditor that I have individually. The exception to this rule is if both my husband and myself owe a creditor together, a creditor can come after our jointly held assets because both of us owe on those assets. But if each of us individually have creditors, anything that we hold in this special way called tenant by the entirety is protected 100% from our individual creditors. And the reason I call it a legal fiction is because tenants by the entirety essentially means that I myself own 100% of the account and my spouse owns 100% of the account, so it cannot be segregated for purposes of paying any debts. I have a question on the screen. I got laid off and I will fall behind on my bills. I have a house with a mortgage and a condo my parents left me that is paid for. How do I protect both? What a great question. Well, first, with your house, because your house is a secured asset, your mortgage company is able to come after and foreclose on that house if you're unable to pay that debt off. So this is critically important that in this time, all federally backed mortgages are currently, you're able to ask and request for forbearance, and it is likely that you are going to be able to receive a forbearance or delay of payment for your mortgage, which would be very helpful in this time. But no matter what, in order to protect your home from being foreclosed on, you have to keep up with your mortgage payments. In terms of a condo that your parents left you, there are various different things that you can do to protect personal assets that are held in that manner, but it would really depend on your individual situation, how we can best plan for that. So having it tenants by the entireties is one example. But what the best thing to do to evaluate rental properties is to talk to me separately and individually. So if you'd like to send me an email, my email is debbie@burkefaulknerlaw.com, or you can call at 727-939-4900, and I'll be able to give you specific advice on that asset, depending on how it's held and how much equity is in there and what your family dynamic looks like. So I'd like to talk a little bit about a couple of other protected assets. One of those being, a couple of financial products are absolutely protected under Florida law. So we already covered, just to recap, your house is protected from creditors under Florida law. Your IRAs, your 401ks, your pension plans are protected under Florida law. From your individual creditors, both you and your spouse might have individual creditors, individual credit card companies and things like that. Anything you own together in a tenant by the entirety manner is protected from individual creditors. So that's an awesome, awesome protection that you have as a married couple that you can secure, and you can move things into tenants by entirety status. Even if you've been married for quite some time, you have assets in your individual names, you can move them into protected status so long as you're not currently facing a creditor situation. There is something in Florida law where if you know that you're already behind, or you're already owing somebody, or there's a potential lawsuit on the horizon that you're aware of, you can find yourself in hot water if you try to make transfers a little bit too close to the time where you may be sued. It's called fraudulent transfer. A fraudulent transfer is a transfer that is made for the purpose of delaying or hindering creditors. So it's very important that if you are doing estate planning or a specific type of transfer planning, that you do so in a way that's going to not get you in hot water under both bankruptcy law and under state law. There's another question on the screen. How can I protect my investments accounts just in my name? That's an awesome question. So there are two types of investment accounts that are protected under Florida law. There are annuities and life insurance policies. Under life insurance policies, both the proceeds of your life insurance policy and the life insurance policy itself, including all of the cash value buildup, is 100% creditor protected. So there is not any other financial products out there, just annuities and life insurance policies that are 100% creditor proof in Florida. So one of the great things about that is that if you already have a life insurance policy, that there are a lot of hybrid policies out there that allow you to make investments in the stock market and also to build up cash value in that way. Those are protected no matter who you are sued by under Florida and federal law. And there's another type of account called a wage account that is also protected under Florida law. And what this means is that the head of a household, if you are responsible for dependents in your household and you are the primary wage earner, you can have a special type of account called a wage account that you could keep 6 months of wages in there, and all of those wages are protected from creditors. I'm going to call my friend Glenn Fasani up here to talk a little bit more about wage accounts. Glenn?
Thank you. And it's interesting because this asset protection concept in Florida is very good because, like Debbie said, there is a lot of protections in the state of Florida that a lot of places don't. A qualified wage account is something that a lot of people, and oh, by the way, if you go to your local bank and say, I want to open a qualified wage account, they're going to go, huh? And it's part of the Florida Constitution, right? It's part of the Florida law. And it basically says that you and we'll get Debbie to come back and talk about specifically what the definition of wages are, but let's use a very simple concept. You get a paycheck every week or every 2 weeks, and that is called your wages. What you're going to do is you're going to go down to your bank and you're going to say, hey, these people on a YouTube channel told me I should have a qualified wage account, and they're not going to know what you're talking about. But basically, it's very simple. You're going to divide out and open up a checking account. It's just a plain old checking account. What I recommend, and what a lot of the attorneys and the people that use wage accounts recommend, is that you go ahead and set up that account, and it should not have any interest in it, or if it does have interest, which basically is zero these days, but if it does have some interest, you should have it swept out of the account on a regular basis, once a month or whatever, and sent to another account. So the concept is you are going to have your money, whether it be direct deposited into that checking account, nothing else gets mixed in with that account. I repeat, nothing else. If you get a $50 rebate from Apple, do not deposit that in your wage account. It is specifically for your wages. So it's a conduit that would basically stop anybody or creditor from attaching your wages. So think of it like a protective conduit. We all know that we put wires under the ground in a protective conduit called a pipe, so that if someone with a shovel doesn't go through the pipe and get electrocuted. But the concept is the same thing. So now, as your wages are coming through this account, the minute it hits your wage account, you can take it and you can transfer it from that wage account to your other account to pay your bills. You can write checks out of it. The concept is the only money is going into this wage account is your wages. Debbie's going to come back and talk a little bit more about what specifically the word wages means. I only want to give you one other piece of advice on a qualified wage account. It's a checking account, again, nothing magical, nothing mystical. And what I would do is when you have the checks made, and people don't even get checks made, but I'd recommend doing this, get a checkbook made and have the title of the checks that you have made say, in my case, Glenn Fasani, qualified wage account. It's just the notation underneath the name and address that you usually put on there, because to me, that's a really good way if you are having to prove and try to use the wage account to stack up 6 months of your wages in case there is a lawsuit, in case there is some sort of situation. You can keep that 6 months worth of wages in that account and have it protected. So hopefully I explained or demystified a little bit the qualified wage account. You can look real smart when people get to hang out at the bars again, and you can say you know about qualified wage accounts. But Deb, talk a little bit about the concept of wages and what exactly is this that can be protected by this kind of account.
Thanks, Glenn. So wages, really what the crux of what Glenn is getting at is that wages are the income that you receive upon which you pay employment taxes. So for those of you who do not have LLCs or professional associations or businesses of your own, this is going to be your paycheck. But it does not cover dividends, or K1 income or K1 distributions, that type of wage. If you're a person that is self-employed and you're able to kind of play with what your wages are and what your distributions are, there's been cases in Florida bankruptcy law, under Florida bankruptcy law, that they've said, no, you cannot protect your wages in this instance. You can only protect your wages if you receive a regular paycheck and they put that paycheck in the account for 6 months. But on a separate note, I just want to say you can piggyback various asset protection strategies. Some of our clients, a lot of our physician clients, they use a qualified wage account that they also put in tenant by the entireties with their spouse. So if one spouse is a physician and one spouse is not a physician, they open a tenant by the entireties wage account at the bank. That account, once the check comes in, that's the qualified wage account for the head of household, the physician in this example, and then their husband, who's the non-physician in this example. They can own that account with them, tenant by the entireties, and then they have a double layer of protection. And there are different types of strategies that you can employ all across the asset protection planning strategy map, I guess you could say, where you can piggyback one strategy onto the next. But the key to remember throughout all of this, guys, is that if you anticipate that you're going to have a problem in the future, it is time to do your asset protection plan and analysis right now. Because there is a concept under Florida law, under federal law, under bankruptcy law, under different layers of law, that if you are already in a situation where you're knowing that you're going to have a creditor issue, in the sense that like somebody's already sent you a letter, you're already in hot water, somebody's already threatened to sue you, and there's a time frame, 2 years and 4 years of a look back, depending on which law that we're working with, 2 year to 4 year look back period to see what you've done in that time frame that could be considered fraudulent. And under Florida law, a fraudulent transfer is one that is for the purpose of avoiding your creditor, or it is to hinder, delay, or defraud a creditor. And one of the ways that you can do this is to make, like if I, for example, wanted to sell to a family member one of my properties for under fair market value, just to get it out of my name, that would be considered a red flag transaction. There's a question on the screen. My wife owns a small business and she got the government loans and she's okay for now. If things end up not getting better, can she restructure the loans? That's an awesome question, but also a very hyper-personalized question, because there are different loan programs that the government has come out with, and each loan program, depending on which one she applied for, has different set of rules and regulations. And here at Burke Faulkner Law, we're keeping up with those regulations and on a day-to-day basis, and we just need to do a personalized analysis of which loan she applied for, what rules apply, and then we'll be able to give her advice. Guys, we're running out of time here, so I want to ask for you to subscribe to this channel so you can get updates on all of our upcoming seminars. This asset protection overview is really for individuals, but we are going to do one for business owners, because business owner asset protection planning is a lot more complicated and has a lot more nuances in it. So I didn't want to overcomplicate this situation today. But I'm just going to do a quick recap from a overview perspective. Your exempt assets that you probably have in your portfolio are your house, your homestead property only, not any other real estate, your IRAs, 401ks, pension plans, life insurance policies, annuities. Those are all protected assets. And if you already have a qualified wage account, I bet most of you don't, that's also a protected asset. The assets that are potentially exposed that you probably own are vehicles, your brokerage accounts. If you keep an extensive amount in brokerage accounts, that's also an exposed asset. And if you have assets that are tenant by the entirety, those accounts are exposed to any joint creditors that you may have as husband and wife, but it's a great asset protection strategy to protect against individual creditors that either of you may have. So I wanted to quickly say that we do a full asset protection red light, green light analysis here, where we can go step by step through your portfolio, your individualized portfolio, and kind of go through the liability exposure that you may have, go asset by asset and discuss risk mitigation strategies with you. We can go over titling, because titling in Florida really means everything, guys. If an asset is properly titled, you may avoid having that asset subject to creditors altogether. And we would go through the process of, analyzing, is this asset, exposed in state court? Are the proceeds of the asset exposed in state court? So like, for example, if you have an IRA, that's protected, but once it's paid to you, is that protected? So those are two different questions. Is the asset exposed in bankruptcy, or the proceeds of the asset exposed in bankruptcy? Two different areas of law. Is the asset exposed to husband's creditors, wife's creditors, or joint creditors? So really, this is a question of 7 different questions for each asset. We go through and analyze one by one whether the asset's exposed in each different potential creditor scenario, and then we're able to give you a full asset protection analysis and help guide you through the different strategies you can employ to protect all the things that you do have and mitigate any risk exposure that you have. So normally to do a full creditor protection analysis is $1,200. For the first 5 customers who are interested in taking care of that, we'll give you a $250 discount. For $1,000, you'll have your full asset protection red light, green light strategy. So I invite you to contact us, Debbie at BurkeFaulknerLaw.com, or you can call us at 727-939-4900. We are open through the stay-at-home order because we are considered a essential business as lawyers. So I invite you to contact me, and we can discuss your individual questions and individual circumstances as soon as you make that call. Thanks, guys, for joining us today. I look forward to seeing you next time.